Please the court. Counsel. Good morning. In these types of cases, when we get to this point of the trial, when I have to stand up and give a closing argument, oftentimes I wonder, am I going to be able to say the right words that'll do honor to the people who are involved in this case? You see, this is a case, a lot of times when we present these cases, names are mentioned, stories are told, but what gets lost in the shuffle is that these cases involve real people. And the real people in this case, what this case is all about, is Amanda Colley and Lindy Dobbins. You've heard during the course of this trial some information about Amanda Colley. She had a dream to one day possibly be an advocate for domestic violence. You heard about Lindy Dobbins, her children, her stepson, who she inspired to get his driver's license. That's who these people were. A daughter, a sister, a friend, a wife, and a mother. Amanda Colley and Lindy Dobbins were human beings. And now they're dead. And they're dead because of one man. The choices that one man made. The selfish choices that he made on August the 27th of 2015. The choices that he made for his own selfish desires, because he couldn't let things go, because he was losing control, and this was the only way that he could regain control. Now, your job is nobody is going to put it lightly. It's going to be a difficult job. Nobody envies the job that you're being asked to do in this particular case. It is a solemn one, but it is an important one. It is a job that requires great courage. So what is your role here today at this phase of the trial? It all starts with the law. Now, it is true, and I'm sure the defense will tell you when they get up here, that there will be no requirement at any point in time, legally, that you return a verdict for the death penalty. However, it is the law, and we talked about this during jury selection, and each of you agreed and took an oath that you would do that. You would consider in this case, you also said you would consider life without the possibility of parole. And so I'd like to spend some time with you, talk to you first about your role in this particular case, and then talk to you about the law that applies in this particular case, and sort of how you go about looking at the evidence that the state has presented you in this case, and how to weigh the different pieces of evidence. So what you're going to learn in a few minutes during the jury instructions the judge will give you is that it's now your duty to make a decision as to the appropriate punishment that the defendant should be imposed on the defendant for the crime that he committed, the first-degree murder of Amanda Colley and the first-degree murder of Lindy Dobbins. And there are two possible punishments, as you know, and it's life without the possibility of parole or death. And it is important that you follow the law that are spelled out in the instructions. And I know I don't have to give any big speech about that. Everybody, we talked about that during jury selection. We have full confidence that you will do that. You all said you would do it. You took an oath to do it, and we have no doubt that you will do it. So what is it that what are the questions that you're going to be looking at today as you evaluate the evidence in this particular case? And essentially, it's broken down into 4 questions. Number 1, has the state proven at least one aggravating factor beyond a reasonable doubt? Number 2, are the aggravating factors that the state has proven beyond a reasonable doubt, are they sufficient to warrant imposition of the death penalty? That's the second question that you will be considering today. Number 3, do those aggravating factors outweigh the mitigating circumstances that you find to exist in this case. And then lastly, based on those considerations there, these questions, should the death penalty be imposed? Now, one of the things that lawyers, we sometimes get caught up in sort of the verbiage. And we know that you folks, you came, you got summoned, you probably didn't really want to be here. And you got called in, you spent a day or two, however long it was with us. We asked you all kind of questions, some of them very personal questions that made you uncomfortable. And then you got selected, and wasn't exactly a choice. And then you get lawyers standing up in front of you and they're throwing around terms like aggravating circumstances and mitigating circumstances, and you probably may not have ever heard those terms before. And I think it's important to kind of explain to you what those are and how they factor into the decisions that you'll be making here today. Well, what you need to understand is that when it comes to an aggravating factor, that is the initial standard, the guide that you will use in making a choice between the verdict of either life in prison without the possibility of parole or death. And the judge will tell you an aggravating circumstance is a statutorily enumerated circumstance that increases the gravity of the crime or the harm to the victim. And so it's not just any first-degree murder that qualifies for the death penalty. It has to be a first-degree murder where the circumstances of the case or who the crime was committed against shows that there's an increase in the gravity of the crime or harm to the victim. And of course, as the judge will tell you, it is our burden, the state's our burden to prove each of those aggravating circumstances beyond a reasonable doubt. And that your finding on that has to be unanimous. So what are mitigating circumstances? Those are circumstances that include any aspect of the defendant's character, background, that reasonably indicate that the death penalty should not be imposed in this particular case. And it could be anything. Now, just like it's our burden to prove an aggravating circumstance, it is the defendant's burden to prove a mitigating circumstance. It is their burden. Now, they don't have to prove it beyond a reasonable doubt. They only have to prove it by greater weight of the evidence, but it is their burden to prove. So, the judge will also tell you when it comes to aggravating circumstances and mitigating circumstances, it is not and Ms. Dunn talked about this during opening statement, it is not a mathematical calculation. The state is limited in what aggravating circumstances are out there, and depending on what the facts of the case are, it's limited. It's unlimited in terms of the mitigating circumstances. So it's not, you don't just calculate, okay, there's 4 aggravating circumstances on one side and there's 15 mitigating circumstances on the other side. The 15 win and we go home. It is not a mathematical calculation. It's a weighing process. And I know I looked here behind the judge's bench here, and there's a set of scales. And these scales are an important symbol of justice in our system. And the mitigating and the aggravating circumstances in a case like this, it's a good idea to kind of reflect on that and to kind of have that idea of scales. And then when you talk about aggravating circumstances and mitigating circumstances and the way that you may assign to each of those, oftentimes you will have one circumstance or a factor that weighs much heavier than another. And so as you are going through the aggravating circumstances and the mitigating circumstances, I want you to think about the weight that you would give each one of those factors. You may have one aggravating factor that outweighs all of the mitigating factors, and it could be numerous. And so that's just kind of an example of what it means by weight and how you go through that process. In this particular case, it starts with your conviction in this particular case on counts 1 and 2. Count 1 is the first-degree murder of Amanda Colley, and count 2 was the first-degree murder of Lindy Dobbins. These are the only two counts that this verdict would apply to. So let's talk about the aggravating factors in this particular case. In count 1, the first aggravating factor that you will be considering, and I'm going to talk about the evidence in just a minute, But the first aggravating factor that you will be considering in this particular case is that the defendant in this particular case was previously convicted of another capital felony or another murder, first-degree murder, or a felony involving the use or threat of violence to another person. The second aggravating circumstance that you will be considering today is that the murder in this particular case was committed while the defendant was engaged in the commission of a burglary. Number 3, that the murder was especially heinous, atrocious, and cruel. Number 4, that the murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. And then finally, that the defendant was subject to a domestic violence injunction, and the victim in this case, Amanda Colley, was the person who obtained that injunction. On count 2, the first 4 factors, basically it's essentially the same first 4 factors. The only thing that doesn't apply with regard to this count 2, which is the murder of Lindy Dobbins, is the 5th aggravating factor, and that was the injunction factor. And that only applies to the murder of Amanda Colley. So let's first talk about these first 4 factors. The first 4 factors that apply to both the murder of Amanda Colley and Lindy Dobbins. And what is the evidence that the state has presented to you in this particular case? Well, as I said, the first aggravating factor is that the defendant was previously convicted of another capital felony or a felony involving the use or threat of violence in this particular case. Well, the crime of first-degree murder, in this particular case, we have 2 first-degree murders. We have, when we're considering the murder of Amanda Colley, there's also a second murder of Lindy Dobbins. And the crime of first-degree murder, that is a capital felony. And because it's Ms. Dunn explained to you in the opening statement, a conviction that happens contemporaneous with another crime, actually it counts in terms of this aggravating factor. So when you're considering the first-degree murder of Amanda Colley, you can consider the murder of Lindy Dobbins as an aggravating factor. And why is that? Why is that? Why does that aggravate the crime? Well, when you stop and think about it, if he killed one person, it may not necessarily be an aggravating factor. But if you found out that years before he had killed a second person, obviously that would aggravate the first-degree murder. You would consider that. In this particular case, I think a lot of times we might get the impression that because it all happened in the same event, that it all kind of subsumes within each other. But because in this particular case, he not only killed another person, but also he tried to kill 2 other people, those also will count as for this aggravating factor. And as well, the 2 attempted first-degree murders, the attempted first-degree murder of Lamar Dubberly as well as Rachel Dobbins. So you would consider this as one aggravating factor, but because you have 3 different crimes, the murder of Lindy Dobbins as well as the attempted murder of Rachel Hendricks and Lamar Dubberly, you can consider those crimes, those additional crimes, in terms of weight. And I would argue to you that you should give this aggravating factor in this particular case great weight. The second aggravating factor that you will consider in this particular case is that the defendant was engaged in the commission of a burglary. Now, you have already found unanimously this particular aggravating factor. All of you unanimously agreed when you convicted the defendant of count 3, this was the burglary that he committed when he killed Amanda Colley and Lindy Dobbins. How does this aggravate that crime? Well, when you stop and think about it, if a crime happened in public, that's one thing. But a person's house is a place where the law recognizes that that is a place where a person should feel the safest. There's a term called a man's home is his castle. And the reason for that is because out of all the places that we have in our society, your home should be the place where you feel the safest. If you can't feel safe in your home, you can't feel safe anywhere. This was Amanda Colley's home. The defendant had an injunction against him. He was not allowed within 500 feet of the home. And instead of obeying that injunction, the defendant broke into her home and committed this crime. And so in this place where Amanda Colley should have felt the safest, the defendant violated that in order to commit these crimes. The third aggravating factor that you will consider in this particular case is that the murder was heinous, atrocious, and cruel. So what does that mean? What does heinous, atrocious, and cruel mean? Well, the judge is going to read you some instructions on that. He's going to tell you that heinous means extremely wicked or shockingly evil. He's going to tell you that atrocious means outrageously wicked or vile. He's going to tell you that cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. He will tell you that the kind of crime intended to be included, especially heinous, atrocious, and cruel, is one accompanied by additional acts that show the crime was conscienceless, pitiless, and was unnecessarily torturous to Amanda Colley and Lenny Dobbins. So let's talk about that for just a minute. Well, what we have here, we hear on the 911 calls exactly what we're talking about in this particular case. And then the call made by Lenny Dobbins.
Put it down. It was the same area. Okay, is it populating?
So what do we hear in these phone calls as it relates to this aggravating factor? Well, we know from other testimony in this particular case that the defendant shot into the house twice before these murders were committed. We know from testimony that Amanda, Lindy, and Rachel fled and ran to hide in the master bedroom. And then the defendant, who is armed with not one, but two firearms, enters the house and goes into the master bedroom where they are. And at this particular point in time, the defendant is invested. Once he pulls the trigger for the first time, he is invested in this murder. These murders. We hear Amanda Colley on the 911 call pleading with the defendant, pleading with him to put the gun down, pleading with him. And then we hear the defendant shoot her. Then we know from the medical examiner's testimony that Amanda Colley didn't die from those first gunshots. We know that after he shot Amanda Colley, from the evidence, that he then forced entry into the closet by kicking it and then shooting through the closet door. Then we know from the 911 calls he enters the closet. We hear it. He shoots Amanda. We hear him shoot into the closet. And then we hear him shoot Lindy twice in the head and in the shoulder. Execution style. Then the defendant, we hear on the 911 call, returns to where Amanda Colley is. We hear Amanda again pleading, no, no, no. Initially it's very soft on the 911 calls. We hear the defendant drop the 9mm. He used the 9mm to shoot into the house. He used the 9mm to initially shoot Amanda Colley. He used the 9mm to shoot and kill Lindy Dobbins. And by the time he got done with all of that, his gun was empty. And when he goes back to Amanda Colley, the gun is empty. He drops it on the floor and pulls out his Smith & Wesson .45 caliber firearm. We hear the defendant call Amanda Colley a fucking whore. We hear Amanda then louder scream, no, no, no. And then the defendant shoots her 5 times, finishing her off with that .45 caliber handgun. So what does this indicate? As the judge will say, when it comes to heinous, atrocious, and cruel, if there's evidence of complete indifference to suffering, that's heinous, atrocious, and cruel. The defendant going into this home, shooting Amanda, still alive, goes in, shoots Lindy, comes back, Amanda's pleading for her life. He doesn't care. Completely indifferent. He doesn't care. That's heinous, atrocious, and cruel. What else with regard to this aggravating factor? Well, we know from the medical examiner's testimony that for the first 3 or 4 shots, Amanda is likely standing or slightly bending over. You heard that two of those gunshots went through her almost at a horizontal pattern, and Dr. Bulick said that's consistent with someone standing. Another one was she was slightly bending over. Another one was to her hand. And we heard evidence in this particular case where the defendant told some of the doctors that he remembered Amanda Colley reaching out for the gun, trying to stop him, and he almost shoots her thumb off. We know that Amanda Colley was shot a total of 9 times. 9 times. Not once, not twice, not 3 times, 9 times. We also know from Dr. Bulick's testimony that several of these gunshot wounds were defensive injuries. We also know from Dr. Bulick's testimony that many of these gunshots were extremely painful. He talked about the ones that went through her ribs, the one that went through her thumb, the one that when she's trying to put her leg up, trying to shield off these bullets, futilely trying to shield them off, one enters her leg below the knee, goes through her knee, and essentially blows her knee apart. Dr. Bulick said this would be extremely painful. We also know that out of all these gunshot wounds, the gunshot that severed her spinal cord which was the most immediately fatal. And it was one of the last, if not the last gunshot. And why is that important? Why did we take the time to kind of go through that with Dr. Bulick? The reason is because as Dr. Bulick said, that all of these it wasn't until this gunshot, all these other gunshot wounds were not immediately lethal. We see from the defensive wounds that Amanda Colley was alive and trying to fight back. We see here the gunshot wounds to her body. 9 times the defendant shot her. Not with 1 firearm, but with 2 firearms. We see defensive wounds to her hand, to her arm, to her legs, to her other hand. What does this show? Amanda Colley was conscious throughout this struggle. Amanda Colley was fighting for her life. And the defendant was not to be deterred. He was on a mission. And that last gunshot wound the one that severed her spinal cord. And Dr. Buick said, when that bullet severed her spinal cord, that would have made her a quadriplegic. She would not have been able to move her limbs, her arms, her legs. She wouldn't have been able to stand up. And that same gunshot wound was the one that went through the hand. It went through the hand, then it went through her neck, and then into her spinal cord. So even with the last shot, Amanda Colley had her hands up, fighting for her life, trying to defend herself. Futile as though it may be, from these gunshot wounds, that this defendant, those gunshots that he was firing at her. So what else do we see with regards to this aggravating factor? Going back to the beginning of this, he fired into the house twice. Everyone runs and hides out of fear. The defendant is yelling, "Where is he? Where is he? Where is he?" Again, as we said before, the defendant is invested in this plan. He has crossed the Rubicon. As soon as he fired those first gunshots, there was no turning back. He had an injunction against him. He had burglarized the house the night before. He was angry. He was mad. Amanda Colley was seeing someone else. She was moving on with her life. He was losing control. And once he fired the first gunshots into this house, he had crossed the point of no return. He was fully invested in his plan. He was on a mission. Amanda Colley and Lindy Dobbins, they're trapped in this bathroom with no place to run. The defendant, again, he shoots Amanda, and he shoots through the door where Lindy is hiding. You hear Lindy on the 911 call screaming, "Oh my God, oh my God, oh my God." He enters the closet. He shoots Lindy twice in the head area, and then he returns to Amanda while she's pleading with her life and finishes her off. So what does this show? He has no conscience, no pity. If you stop and think about what was going through their minds when they heard the first gunshots outside and they ran to hide, and the defendant comes into the house with these guns. Where is he? Where is he? After hearing the first shots, they know what's about to happen. They're contemplating their own demise at this moment. And that contemplation increases when the defendant shoots Amanda Colley for the first time. You hear, and then Lindy Dobbin, he shoots into that closet and that bullet hits her in the foot, and she's screaming, "Oh my God, oh my God, oh my God." She knows what's about to happen. He enters that closet. She has nowhere to go. Nowhere to go. And she's cowering in fear behind that dresser as this defendant, with no conscience, no pity whatsoever, walks into that closet, points the gun at her head, and shoots her execution style. That's heinous, atrocious, and cruel. The fourth aggravating factor that applies to count 1 and count 2, the aggravating factor that you will be considering today, is that these murders were committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. I want to talk about that last part real quick, without any pretense of moral or legal justification. There is no justification in this particular case. I don't know that anybody's going to argue otherwise. I know that we've heard people make statements, testify about how Amanda Colley would pull him in and then push him back out, and she was cheating on him. And there was no justification for this. There was no justification. The defendant, had a girlfriend, but he didn't want Amanda to move on. There was no justification for what happened here. The judge will tell you when it comes to cold, calculated, and premeditated that cold means that the murder was the product of calm and cool reflection. That calculated means having a careful plan or a prearranged design to commit the murder. And that in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. If you remember, we talked about in jury selection, and in the first phase of this trial, we talked about premeditation. We talked about how the law does not fix an exact period of time that's required for premeditation. As long as there's sufficient opportunity to form the intent to reflect on what you've decided to do, have an opportunity to change your mind, and yet you go ahead and do it anyway. That's premeditation. Well, cold calculated and premeditated is a little different. It does require a substantial period of reflection in this particular case. But the evidence here shows that the defendant had that opportunity. He had a substantial period of reflection in this particular case. So let's talk about the evidence in this particular case as it relates to this particular aggravating circumstance. Well, we know from the evidence, we heard the text messages, or we saw the text messages, we heard the voicemails, we heard all this evidence that the defendant was angry. He was suspicious that Amanda Colley was seeing someone else. He was keeping tabs on him. He was not allowed at the house, and so he had Mike Dickens kind of looking out for him, sending him texts. Hey, is Amanda's vehicle there? Hey, do you see any other vehicles in the driveway? He had somebody looking out for him. We saw the text messages to Mike Dickens where he's referring to Amanda as a bitch, as a whore, as evil. We know that he had Amanda Colley in his phone. He didn't have Amanda Colley. He didn't have wife. He had her in as bitch. That's the way this defendant thought of Amanda Colley. He was angry. And then we saw the text message that he sent to Mike Dickens that says, now she's going to pay. And that's what we saw in this particular case. Amanda Colley paid, and he made sure of it. We know that Mike Dickens sent the defendant that text of Lamar cutting her grass. And this was fueling this anger. And those suspicions, his suspicions were confirmed the night before. He broke into her house, found those items, the sexual paraphernalia, and he got so angry that he smashed 3 TVs. And then, from that point forward, harassing phone calls, harassing texts to Amanda Colley. This began to build. This was not a sudden thing. This anger and this hatred began to build. And then at 8:51 a.m., you saw the text earlier for the testimony, I believe it was of Detective Colley. He sends a text, call me or I'm going to come find you. Well, at 9:12, he's in court. He has a court appearance. So he goes to court and he enters his plea. And then after he leaves court, between 9:41 and 9:55, he places a phone call to Amanda. And that phone call lasts over 13 minutes. And we know from the defendant's, what he told the doctors, and we found this out during the defense's case in chief, when the doctors got up and they testified about going and evaluating the defendant, what his story was, what he told them. We know from him that he talked to Amanda Colley, and she told him on that phone call that the police were called. And we know from what he told the doctors that she wasn't the one that called the police. She told him that. Which only left one person to have called the police, and that was Lamar. And that made the defendant angry. Because he knew he had an injunction. He wasn't supposed to be there. He knew that he had burglarized the house. At 9:57, we know the defendant is in the area of 95 and 210, and he attempts to call Amanda. At 10 o'clock, he's at the Speedway in front of the neighborhood where he lived in Southampton. At 10:03, he sends a text message to bitch, saying please. And so you could see this constant, he would call her up and he would say angry things to her. And then he would leave a voicemail saying please. And then he left a voicemail on Amanda's phone at 10:07. After this 13-minute phone call. Again, he's on his way back to his house. And then at 10:07, he's at home. You hear somebody saying, "Get back," and you hear someone say, "You're a moron." After this 13-minute phone call with Amanda Colley where she told him they had called the police, she wasn't the one that did it, he knew it was Lamar, he made a decision. That was the straw that broke the camel's back. It wasn't enough that she was seeing somebody else. It wasn't enough that she was doing things with Lamar that she wouldn't do with him according to what he said. Now, her significant other had called the police on him because he had broken into Amanda's house. And a decision was made during that phone call to go home and get those guns, the 9mm and the .45. And you hear in this phone call, as he's getting those guns, he butt dials Amanda. You can hear in the background. You hear him say, "Get back." You hear, likely his dad, saying, "You're a moron," as he's grabbing these guns. We know from the photographs from the crime scene technician, Chris Keegan, who processed the defendant's bedroom, that a 9mm handgun case was found under his bed. That 9mm case matches the serial number for the Ruger 9mm. It was in his bedroom. I know we heard testimony from Rhonda Colley that said, "Those guns were mine. I had them in the car." Well, the evidence shows that that's not true. And she couldn't even, when she was telling the police, trying to describe the gun, she couldn't keep it straight. She didn't know what caliber guns they were. She didn't know what color it was. She said they came in a box, but I don't know what the color of the box was. She said that they were put in between the seat, but we know from the defendant's statement to doctors that they were in the trunk, according to him. That box to that 9mm was under his bed. The .45, the box was in Amanda Colley's house. Wasn't found in Rhonda's bedroom. It wasn't found in her car. They were found in his former house, and the 9mm was found under his bed. The handgun holster was found in the middle of the floor of his bedroom. And then we saw the photographs of the ammunition, the gun case that was scattered on the left side of his bed. And the ammunition, there's the gun case, there's the holster, there's the gun case there with all that ammunition. And these .45 caliber zombie rounds that were found in his bedroom, the ones with the green polymer tip, were the exact same kind and caliber of bullets that were found in Amanda Colley's body and was found in that car that he was arrested in Virginia. As well as these 9mm Luger bullets were found in his bedroom. These match bullets that were found at the crime scene and in Amanda Colley's body. Again, the Ruger 9mm case was found under his bed. The .45 was found at the home on Bellagio. What other evidence is there that this murder was committed in a cold, calculated, and premeditated fashion? Well, we know that at 10:11, we have video from the speedway on 210 that shows the defendant pulling up to the gas pumps. There was a lot of kind of back and forth about why would somebody get just a few dollars of gas. Well, you would get a few dollars of gas if your intention, before you go and commit these murders. This was before 10:11. This is about 20 minutes before these murders are committed. He's topping off because he knows what he's about to do. And he knows that when he gets done doing what he's about to do, he's got to get out of Dodge. And he doesn't want to stop for a long time. And so he's going to fill up his tank as full as he can get it. So when he's done committing these murders, he can leave as fast as he can and get as far as he can before he has to stop and get gas. That's why he's topping off. That's the only reason he would do it. We know at 10:14, he's making a purchase at that same speedway, and he's buying some beer, trying to calm his nerves, trying to get a little liquid courage before he's going to do what he's about to do. Between 10:02 and 10:13, the cellular mapping puts his activity on his phone at the home tower, that cell phone tower near his neighborhood. What does this indicate? He has a careful plan, a prearranged design. After that 13-minute phone call, he decided what he's going to do. He goes to his home, he gets those guns. He goes to the store, he tops off that gas. He gets a beer to give him some courage to complete his mission. That is cold calculated and premeditated, ladies and gentlemen. So what else is there? We know that when he leaves the gas station, he has to drive to Amanda Colley's house. Now, it's not just up the street. To get from the Southampton neighborhood to Mirabella, it's 15 miles away. And so he has to drive and drive and drive. 15 minutes. And that's assuming he's driving 60 miles an hour, which he likely is not. It's not the interstate. So he's driving 20 minutes. Time to think, time to contemplate, time to consider, time to reflect on what it is that he is about to do. This is not a quick decision and an act. He has to drive 15, 20 minutes from his neighborhood to Amanda Colley's neighborhood to carry out his mission. And then we know at 10:22, he makes a phone call to Bitch. No answer. At this point, he's on the west side of his home tower. 10:23, he sends a text to Amanda, to Amy Mason, his girlfriend, saying, "I love you." At 10:26, another phone call to Bitch. No answer. At this point, he's on the south. He's south of 210 on Highway 16A. He's getting closer to Amanda Colley's house. 10:28, he gets a phone call from Dad. It'll last about 55 seconds. At this point, he's on Highway 16, closer to Mirabella. At 10:31, he gets another phone call from Dad that happens, lasts for about 20 seconds. And at this point, he's at the Mirabella neighborhood tower. Now this lines up almost perfectly with the testimony of Brittany Mano. She was the one, the dog walker, that went to the home across the street from where the defendant lived. And she's there. She shows up around 10:15. She gets the dog to take it for a walk. And as she's taking the dog for a walk, she hears the defendant's dad on the phone. Now this is before the murder. Before the murder, she was very clear about the time. And the time that she testified to matches up with the phone records that show that the defendant was on the phone with his dad. And what is the dad saying? "Son, don't do it. Don't do it." And she hears the person on the other line saying, "I can't take it anymore." The defendant knew what he was going to do. He knew what he was going to do. His father, his own father, is pleading with him, "Son, don't do it." And does he listen? No, he doesn't listen. He doesn't listen to anybody. He doesn't listen to the court when they put an injunction in place. He doesn't listen to his dad pleading with him. He doesn't listen to Amanda when she's pleading for her life. He doesn't listen to anybody. He's on a mission. He's going to do what he's got to do. So what does he do on this mission? After driving that 15 to 20 minute drive to the Mirabella residence, does he go to the front driveway? No, he doesn't go to the front driveway. He doesn't want to be seen. So he goes to the house behind Amanda Colley's house. He goes through the wood line. He crosses the berm across the path to Amanda Colley's house. This shows clear and convincingly, beyond a reasonable doubt, the defendant is doing this because he doesn't want to be seen, he knows what he's going to do, and he wants to conceal his movements as he approaches the house. What does it show? Again, a substantial period of reflection. He's thought about this. He knows exactly how he's going to do it. How else have we shown that these murders were committed in a cold, calculated, and premeditated manner? Well, he fires, again, 2 shots from the backyard into the house, yelling, "Where is he? Where is he?" He's on a mission. He's on a mission. He's looking for Lamar. He's looking for Amanda. He shoots Amanda. He shoots through the closet door. He enters the closet. He shoots Lindy twice in the head, calls Amanda a fucking whore, drops the firearm on the floor, and then shoots her several times with a .45. Didn't care. He was on a mission. And he accomplished his mission. Lindy Dobbins, all this talk about Amanda cheating on him, seeing this other guy. What did Lindy do? I mean, we heard text messages that he sent to Mike Dickens. She was interfering every time that Lindy would be talking to Amanda. 30 minutes later, Amanda would tell her, "I don't play anymore. I don't feel anything for you anymore." He thought Lindy was interfering. So he had some resentment, some anger toward Lindy as well. Lindy, what did she do other than that? Nothing. She was in the wrong place at the wrong time. She was there to help her friend. She gets a call. She leaves work. She finds out that her friend, that her estranged husband the night before broke into her house, busted TVs, a violent act. And out of concern for her friend, she leaves her job. She goes to Amanda's house to console her, to help her. And they say no good deed goes unpunished. The defendant accomplished his mission. The 5th aggravating factor, this applies to count 1, is that the defendant was subject to a domestic violence injunction, and that the victim, in this case, Amanda Colley, was the person who took out that injunction. And that was something that we had to prove to you during the course of the guilt phase in this particular case. We know that there was, in fact, a domestic violence injunction that has been placed into evidence. And we also know that the defendant was subject to that domestic violence injunction and that Amanda Colley was the person who took it out. It's right there in black and white on the injunction. And so this right here is the 5th aggravating factor. Why is that important? Why is that important? How does it aggravate these murders? Because he knew. He was told. He wasn't just told by his dad or somebody in his family. He was told by a court. Do not have any contact with Amanda. Do not go to her house. That's what makes this crime different than your typical first-degree murder, because he was flaunting the law. He was thumbing his nose at the law. He didn't care. This injunction to him was nothing more than a piece of paper that stood in his way. And I would submit to you, ladies and gentlemen, as you consider all of these aggravating factors, all 5 of them, when you consider their significance in this particular case, heinous, atrocious, and cruel, how he committed these crimes, what was going on in his mind, the cold, the calculated, premeditated manner in which he committed these crimes, the disregard that he had for the law, for the injunction, for the law that says you can't break into somebody's house and destroy things in their home. You can't break into their house and kill people. When you consider each of these aggravating factors and you're deciding what weight to give them, I submit to you that you should give them great weight. But that doesn't complete your task in this particular case. There have been a number of witnesses, pieces of evidence that you've been asked to consider with regard to mitigating circumstances. Those are things that you can consider in order to conclude that perhaps the defendant, the death penalty is not appropriate in this particular case. And these are things that have been presented to you. And this is the only opportunity that I will get to talk to you. And so I'd like to address some of these that there may be others that I don't know about that the defense may argue. These are some of the ones that I picked up on during the course of this particular trial. And since this is my only opportunity to talk to you, I'd like to address some of these. Well, there were some mitigating circumstances that have been presented with regard to family relationships by the defendant. The defendant, it was argued, or the evidence was presented, that he's a good father to his children, that he's a good son, that he's a good brother, that he's a good uncle. And he comes from a loving and close family. And there's not much that we can argue to dispute that. You know, most families, not every family, but there's a lot of families that have loving relationships with each other. His family is not any different than really any other. And so the argument is made that to consider these close family relationships and how this would affect them. Well, the law that the judge is going to give you is that you should not base your decision on the fact that you feel sorry for anyone or are angry at anyone. And it's true that his family in this particular case, they're victims too. That's true. But that's nobody's fault but the defendant's. Nobody's fault but his. And the question is, how can a volitional, premeditated act such as these murders by the defendant be mitigated by the fact that his crime negatively impacts his family? It's his fault that he's in the position that he's in today. And also, when you consider that, don't feel like suddenly you can't do your job because you feel that sympathy for them, because that's unfair to you. That's not your burden to bear, because you're not the reason why we're here. The defendant is the reason why we're here. And so it's not fair for you to have to carry that burden. That's a burden that the defendant will have to carry. We heard evidence about his employment history, that he was a good worker, that he was gainfully employed at the time, that he maintained stable employment. And again, you may consider this as a mitigating factor. I don't have much that I can argue to you to dispute that. We heard evidence that his influence on others. He did charitable work through his job, that he was a positive influence on other children, that he volunteered as a baseball and football coach, and that he was a mentor to other employees. We saw a lot of photos in this particular case that showed a lot of this. Photos of his family, photos of his kids. So what is all of this? You may consider this mitigating circumstance. The question is, what weight are you going to give it? As you're considering that, you'll see that these photographs and all these show he had a great life. He had a great life. He had a close family. He had good friends, fantastic kids. You saw somebody in these photographs and with that testimony who had chances and opportunities in life. He had every reason in the world, particularly with his kids, every reason in the world to live a law-abiding life. He had sufficient ability not only to get by. We heard one of his co-workers talk about how much money he made. I mean, one of his sisters talking about how much money he did. He was very successful. He was one of the top earners. He had sufficient ability not only to get by, but to thrive. But the defendant squandered those opportunities. He threw it all away. He threw it all away for this selfish act. So is that a mitigating circumstance? That's for you to determine. If it is, how much weight are you going to give it? Nobody forced the defendant to get 2 guns from his home and go to Amanda's house. Nobody manipulated him into shooting into the house, breaking in.
Nobody twisted his arms to shoot Amanda Colley 9 times. Nobody tricked him into shooting Lindy Dobbins in the head. Those are choices that James Colley made on his own. The opportunities that he had in his life, he threw it all away. Nobody's to blame for this situation other than the defendant himself. We heard testimony the defendant loves animals. How much weight do you give that in considering the circumstances of this case? How much weight? You heard that the defendant was previously active in race car driving. How does that mitigate against these two horrific crimes? That's for you to determine. We heard testimony that from his sister that he was a witness to domestic violence by his mother and his father. Crystal Wright took the stand and said that she and the defendant witnessed her mother, or their mother, take a baseball bat to their father because he was having an affair. And then at Thanksgiving, during that same period of time, when she tried to come over and see the kids, she pulled it, and he told her she couldn't come in. He pulled a knife on her. Well, when you consider her testimony, that sounds terrible. That's terrible. But the problem is that she had previously testified she never witnessed any kind of physical violence between her mother and father. In her deposition, she said nothing. No physical violence between the two of them. But she comes to court and suddenly mom beat Dad with a baseball bat and pulled a knife on him. And so that would be something for you to consider. Has that even been established? Is there any credible evidence that that occurred? You have a witness who took the stand and gave inconsistent statements about that incident. The defendant is impulsive. What evidence is there of that? This crime shows the defendant had a very carefully, well thought out plan. Did he draw schematics? No. Did he take days and days and days to plan this crime? No. But it didn't take all of that to carefully plan this crime. You heard evidence that he has a history of drug and chronic alcohol abuse. That he was taking pain medications, antidepressants, and sleep disorder medications at the time of the homicide. That he was diagnosed with depression. That he tried marriage counseling, and that he adjusted well to his incarceration. You'll have to decide, are these mitigating circumstances, have these been established? If you think they have, you have to decide what weight to give it. And then finally, we heard testimony and argument that the defendant was impaired at the time of the homicides, and that his capacity to appreciate the criminality of his conduct and to conform his conduct to the requirements of the law was substantially impaired. So what did we hear? Well, in terms of these two purported mitigating circumstances, we heard from two defense experts, Dr. Daniel Buffington and Dr. Mark Mills. And what did they tell you? Well, they attributed his behaviors at the time of the crime as not really a volitional act, but he was in a parasomnia state. That he had taken the Ambien, he had taken the Wellbutrin, he had taken the Cymbalta, and they had caused him to be in a parasomnia state. And that because of that, he was reporting these snapshot memories. And they said this was consistent with parasomnia. And therefore, this proves that he was under the influence of these medications at the time. Well, the judge is going to give you instruction about expert witnesses. You don't have to believe everything that expert witnesses tell you. He's going to tell you that they're like all other witnesses, except for one fact, and that is they're allowed to give their opinion. That they're allowed to give an opinion about a subject that you think that they're an expert in. He'll tell you that their opinion is only reliable on a subject about which you believe them to be an expert. And like any other witness, there's no magic dust on an expert witness. There is no special credibility because they have letters behind their name. because they have a doctor in front of their name. They're just like every other witness. You can believe or disbelieve any part of it, or you can disbelieve all of it if you believe that's appropriate. He will tell you when it comes to witness reliability, they're just like every other witness. He's going to tell you that when it comes to witness reliability, when you're considering these aggravating factors and mitigating circumstances, it's up to you to decide which evidence is reliable. He will tell you that you should use your common sense. A lot of times when we see people come in there they're well educated. They have doctorates, they're licensed, they have these certifications. But at the end of the day, we talked about this during jury selection, about going to a doctor and not being quite comfortable with something that they say and needing a second opinion. You go get that second opinion and you make that decision. And each of you said, I believe that I have the ability to listen to what different experts say and make up my own mind, use my own common sense as to what is the right answer. And that applies here in this particular case as well. Use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision in this particular case. You may find some of the evidence not reliable or less reliable than other evidence in the case. You should consider how the witnesses acted as well as what they say. Some of the things that you should consider is, did they have an opportunity to see and know the things about which they testified? The doctors are relying on James Colley. They didn't see him take the medication. They didn't see him that particular day. They're relying on what he told them. Did the witness have some interest in how the case should be decided? And this has nothing to do with the money that they made. You know, there was a lot of questions about what do you get paid? You know, $300 an hour, $200. Expert witnesses get paid, regardless of who they're testifying for. They get paid. That's what they do. They deserve to get paid. It has nothing to do with that. It has to do with the defendant. In this particular case, they're testifying about things the defendant told them. So in this essence, the defendant is the witness. Does he have an interest in how the case should be decided? Did the witness's testimony agree with other testimony or evidence in the case? These are things you should consider when determining how reliable is that information. Well, both Dr. Mills and Dr. Buffington admitted that the only evidence that they had, the only source of the information they had, that the defendant actually took these medications and that they actually had the effect that was described came from the defendant himself. They had no other source of that information. It solely came from the defendant himself. And they both admitted that if the defendant lied to them about that would essentially make their opinions in this particular case invalid. So it would adversely affect their opinions because their opinions rely on the truth of that information. So should we trust it? Well, let's ask some questions about that. Well, all the doctors in this particular case evaluated the defendant almost 3 years after the murders. 3 years. Almost 3 years. That's a long time for the defendant to sit and think about what he's going to do, what he's going to tell people, what he's going to tell these doctors. And I know Dr. Buffington, when I asked him these questions, he kind of looked at me kind of sideways like he didn't know why I was asking these questions. He was talking about how he evaluated the defendant, personally talked to him just like he would a client or a patient in an ER or an exam room. But that's not where they evaluated and interviewed the defendant. They were interviewing him in a jail where he's facing very serious charges, the most serious kind of charges. Why is that important? How is that different than a patient in a clinical setting, at a hospital or a doctor's office? Well, the reason is because the reason the defendant is different is because there's a high motivation on his part to fabricate these symptoms. So can you trust that? Well, we heard from Dr. Danzinger. He evaluated the defendant, and he looked at the records. He looked at the information that was provided to him, and he said in the 17 days between when those prescriptions were written and when the murders occurred, there was no ongoing issues. There was no ongoing issues in the days leading up to the homicide. He told you, and again, his opinion was there was no impairment on the defendant's part in this case. That opinion was based on the fact he read a report from a Dr. Harry Kropp, who was a psychologist, who evaluated the defendant for competency and sanity. And he told you that Dr. Kropp conducted this evaluation very close in time to when the murders occurred. A lot closer in time to when the rest of the doctors interviewed the defendant. And he said that Dr. Kropp's report indicated that the defendant was actually able to describe the events that happened after court. And that's important because by the time he's in court, he's already allegedly taken the Ambien, the Wellbutrin, the Cymbalta. He said that the defendant was able to describe those events after court. He said that Dr. Kropp said the defendant told him and he was just simply hung over and snapped. He said that Dr. Kropp in his report said that he never said anything in the report about any memory loss, any blackouts, and that he was able to relate facts to his attorney. And that essentially Dr. Danzinger's opinion was that he was making up facts years later. He also reviewed Dr. Mills. Dr. Mills conducted some psychological examinations of the MMPI, the PAI. And those psychological tests, which were hundreds of questions long, indicated that the defendant was actually anger-prone, irritability, low frustration tolerance, thoughts of persecution. These are the things that Dr. Danzinger said was driving the defendant on the morning of August the 27th, 2015, not impairment. What else did Dr. Danzinger tell you? That he had considered other incidents of violence in this particular case. And one of those was the night before. The doctors say, the night before when he broke into Amanda Colley's home and destroyed her TVs, he wasn't under the influence of the Ambien then. Then there's the deliberate actions by the defendant in this particular case. Dr. Danzinger said, when somebody is on Ambien, they may do some complex things, but they're not going to do them very well. They're going to be very foggy. They're going to be incoherent. But here, in this particular case, there are very deliberate actions by the defendant that show clear thinking. We know that he armed himself with not one, but 2 guns. We know that, again, he tops off his gas tank at the gas station. We know that he buys a beer to calm his nerves. And he drives his car to the neighborhood behind Amanda Colley's house. This is clear thinking. He's trying to conceal his movements. If he was in a fog, if he was sort of an automaton, he would have done those normal, typical things that he would do on a regular basis. He would have just drove up to the front of the house to do this. But no, he didn't do that. He drove to the neighborhood behind Amanda Colley's house. And then we know he flees the area. That shows he knew what he had done and was trying to get out of Dodge. Very deliberate actions in this particular case. Evidence that the defendant's claim is false. Well, we know the defendant is out all night. He gets that call from Daryl the night before. He goes over and they go to a couple of bars, have some drink, do a couple of lines of cocaine. And we know that he has a court appearance at 9 o'clock. And so he comes home around, some people say it was 5 o'clock, and he told Dr. Denning it was like 6 o'clock. He comes home 5, 6 o'clock after he's broken into his wife's house. He's talked to Mike Dickens, and he takes 2 Ambien to get to sleep. Now he's got court in just a few hours. 3 or 4 hours he's got court. And so he takes 2 Ambien at 5 or 6 o'clock in the morning. It only makes sense that you would actually take the Ambien if you had a full night's sleep available to you. They tell you take the Ambien at night before you go to bed. And Dr. Danzinger says, he tells people, don't take it and go to the grocery store. You take it when you're ready to go to sleep. You take it at night. He talked about the half-life, 2 to 3 hours, which means it's basically half as long as it stays in your system. And the reason for that is so you will get a night's sleep. Well, the defendant here, he takes Ambien 2 or 3 hours, 3 or 4 hours, before he has to go to court. That doesn't make any sense whatsoever. And then we heard testimony that the defendant told the doctors that his dad had to aggressively wake him up And we saw there was text messages and phone calls from the time he leaves Mike Dickens' house at 4:30 in the morning all up until the time that he goes to court. He's on the phone. He's calling. He's texting. He's receiving calls time and time and time again. Now, Dr. Buffington tries to explain it away by saying he's sleep texting. That's perfectly consistent. That doesn't prove anything. In fact, I argue to you the contrary. The reason is because he told the doctors his dad had to aggressively wake him up. I asked Dr. Buffington, well, did he tell you that he was sitting up and his dad wakes him up while he's sleep texting, whatever? No. No. He's asleep. Or he's not asleep. When we heard testimony, I think it was the guilt phase from Tammy Folsom, she woke up that morning. What was he doing? He was on the back porch on his phone. He never went to sleep. He never took the Ambien. He was on the phone, calling. He was harassing Amanda, calling her up, telling her, "You're lucky I don't tell the kids about this. You're fucking disgusting." That's what he was doing when he says that he was asleep. He didn't take any Ambien. And then, the most pivotal piece of evidence in this particular case is, we don't have to take anybody's word for it. We had doctor after doctor after doctor get on the stand to convince you that he was impaired. And we got a bunch of fancy words about, what these drugs do and, what kind of an effect. We heard all this stuff about nutritional supplements. I don't know what anything that had to do with anything. There wasn't really much of an explanation for that. The Ambien was really sort of the concentration of the testimony. I'm not sure why the other stuff got brought up. But all these doctors got up on the stand to convince you that the defendant was impaired at the time these crimes were committed. But you didn't need to hear from any of these doctors because you got to see for yourself. The testimony was that he took the Ambien 5 or 6 o'clock in the morning. He goes to court at 9 o'clock. At 9:12, you saw the video, you heard the audio of the defendant in court yourself. You saw a window into that period of time when he was supposed to be under the influence of this Ambien. And what did you see? You saw him taking a plea. You heard the judge going through a plea colloquy to make sure he understood what he was doing. The defendant gave his name. He said where he worked. The judge went to the colloquy. The judge specifically asked him, "Are you under the influence of any intoxicants?" The defendant immediately said no. You hear the judge asking him questions. You hear the defendant responding appropriately. He's not in a fog. He's not confused. On top of that, not only is he answering the judge's questions appropriately, but he volunteers questions. He initiates questions. He asks the judge about early termination of his probation. The judge says, you have batter's intervention permit as a condition of your probation. The defendant tells the judge, completely unsolicited, "I've already signed up. I've got 24 more classes to go." This is not someone who's confused. And then when the judge says you have $474 in court costs, the defendant responds, I posted a $500 bond. Can I take that money and apply it? That's a pretty sophisticated thinking. This is not someone who's in a daze. This is someone who is completely coherent, clear thinking, and rational. You got to see it with your own eyes and hear it with your own ears. You don't have to take Dr. Buffington's word for it. You don't have to take Dr. Mill's word for it. You don't have to take Dr. Danzinger's word for it. You got to see with your own eyes and hear with your own ears what state the defendant was just an hour before he went to Amanda Colley's home and murdered her and Lindy Dobbins in cold blood. There was no impairment at all. And I submit to you that that has not been established, even by a greater weight of the evidence. And you should not consider that as a mitigating factor. And then we heard testimony from both Judge Tinlin yesterday. We heard from the defendant's own attorney at the time, Kyle Bedger, earlier in the guilt phase. And both of them said They had absolutely no concerns whatsoever that they did not think that the defendant was impaired at the time. These were people that actually were in the courtroom with him. Kyle Bedrin was his actual attorney, the person who had had the most contact with him during that period of time. Neither one of them had any concerns and did not think the defendant was impaired. Otherwise, the judge would have taken the plea. And he said he's seen people before actually have issues with impairment, and he's not taken the plea. There were some questions, well, you know, you had a lot of people in your courtroom, you were a distance away, and the judge like, look, I have 7,000 cases a year. 7,000, I see a lot of people. I can tell. But not in this case. There was no impairment. At the end of this case, at the end of all of this, you have to consider what's involved. The last few days we've heard a lot about the defendant. But what this case is really about are two ladies, two women. Two women who had a future ahead of them. 36, and Colley was 36 years old. Lindy Dobbins was 39. Lindy Dobbins had a husband. She had children. She had a stepson. She had parents, siblings, a friend. Amanda Colley had her children, parents, sisters, friends. Many years ahead of them. Their lives were cut short. And they were cut short in the most vile and heinous way. For what? For what? Why? Because he couldn't let go. He may have had a right to be upset, but not like this. Not like this. The defendant was on a mission. Whatever he thought about Amanda Colley, he was not the judge, jury, and executioner of her character. That was not his job. What she did did not deserve a death sentence. What he did in shooting her down the way he did, and shooting Lindy Dobbins and killing her, that does deserve a death sentence. In a few minutes, you're going to go back to the jury room, and you're going to contemplate that verdict in this particular case. And I ask you to deliberate about that. There's 12 of you that will decide that. And it's only going to take one of you to say no. I'm asking each and every one of you, consider the evidence. Consider the aggravating circumstances in this case. Consider the mitigating circumstances. If you do, I'm confident you will find that the aggravating circumstances in this particular case, how the defendant carried out these crimes, will far outweigh whatever mitigating circumstances that you find. And when you find that, I ask you, not 8 of you, 9 of you, 10 of you, or 11 of you, all 12 of you, I ask that you find that in this particular case, this is not a run-of-the-mill first-degree murder case. This is a case where the aggravating circumstances of the case have great weight. What the defendant did in this particular case was horrific. It was not justified. It was unnecessary. And it far outweighs any mitigating circumstances in this particular case. I'm asking all 12 of you, not because I think you should or anybody thinks you should, because that's the right thing to do. And it's going to require courage to do it.
The defendant deserved the death penalty. I'm asking all 12 of you, based on the law, based on the evidence in this particular case, that you come back with that verdict, that the defendant gets the death penalty.